I am Dr. Anita Nwotite from the Department of Public and Private Law, Faculty of Law. This is Module 1, entitled Law and the Regulation of Human Conduct in the Society. This module will expose you to the meaning, nature, and characteristics of law. It will also learn the theories, sources, and classifications. The module will expose you to the different methods through which law regulates human conduct in the society. The objectives of these modules are as follows: to expose students to the nature and concepts of law. It will also expose you to the scope of law, the different ways through which people perceive law. It will further expose you to the constituent elements, that is the characteristics of law, the classification and sources of law, particularly in Nigeria. It will again expose you to the various ways through which law serves as a means of regulating human conduct in the society. Finally, this module will help to inculcate in you respect. By way of introduction, the individuals interacting in the society have competing interests. However, where these interests are left unchecked, the society becomes a jungle where everyone will choose to do what he or she likes. Law, in this respect, comes in to supplement the informal methods of social control, thereby achieving order and peaceful coexistence in the society. Now let us look at the meaning of law. Law, as we know it, means different things to different people. Different societies perceive law in different ways. So also are cultures and religion. To the judges, law means rules of courts, decrees, judgments, orders of courts, and injunctions. To the realist school of thought, law is nothing but what the court says it is. To the positivist school of thought, law is the command of the sovereign. To the society at large, law means justice, morality, order, and righteousness. Now we turn to the meaning of law. Law has no universally acceptable meaning. Just like we have identified earlier, law means different things to different people. And so a lot of ink has flowed in the bid to define law. And that is the reason why we have said there is not yet an acceptable meaning of law. And so different authors have defined law in different ways. For instance, John Austin defined law as a command which obliges a person or persons to a course of conduct. He further defines it as a command set by a superior to the inferior and enforced by sanction. Salmon, on his part, defined law as the body of rules recognized and applied by the state in the administration of justice. Oliver Wendell, on his part, defines law as the prophecy of what the court will do. We can see from this definition that there are no acceptable meanings of law. And so we can rather look at law from the point of the new view of the nature of law. And so law is regulatory by nature. Regulatory because it directs the conduct of people in the society or a group of people in a particular place. Law is also prescriptive It is prescriptive in the sense that law defines what is to be done and then prohibits the opposite. Let us further look at the characteristics of law. Since law has no identifiable or a universal accepted definition, we can rather look at law or identify law by their constituents or some of the elements that are very unique to law, and that's we term characteristics of law. Some of the characteristics of law we have are: 1. Law is normative. Law is normative in character because law is of a nature that prescribes. By that we mean that law sets a standard of what is to be done and then prohibits the opposite. Law sets out what will be done and what should not be done in the society, all for the purpose of regulating human conduct. Law is also made by a sovereign. Now, when we talk about sovereign, by whatever name that sovereign is defined, for instance, in Nigeria, the sovereign or the concept of sovereign we understand from the viewpoint of the legislature, the body that is vested with the power of lawmaking. So whether the sovereign is named a legislature or the parliament, what is important is that law is made by a determinant body. Law is also coercive. For instance, the positivist school of thought are of the view that any law that has no sanction is no law. And from that point of view, we see law as being coercive because law is enforced by sanction. Law is also an expression of the common will of the people. It is true that all of us, particularly in Nigeria, cannot go to the National Assembly to make laws or to legislate. But then we have elected people and have given them our mandate to exercise such mandate on our behalf. And so it is the expression of our will that is the embodiment of the law. Next, law exists in a social context or in a social setting. Law does not exist in a vacuum. It exists within the context of the society. Law is made in the society, for the society, and for the people within the society. Law has territorial limitations or boundaries. What we are trying to say here is that you cannot legislate here in Nigeria and then expect that law to be operative in the US. So each territory makes law that binds the person within that territory. That is the reason why we say it has territorial limits. That is why we talk about jurisdiction. Law is also dynamic. It is not static. It changes with the society. From time to time, the need will arise for laws to be made, and laws will be made in response to the reality in the society. Finally, law is universal. It is universal in the sense that law or group of people in any part of the world have their own laws that regulate their conduct. So that where you come to Nigeria, you find laws regulating the life of the people. You go to the US, you also have laws regulating them. So law is universal, although it will not be the same. But then, people will always have law at a point regulating the conduct of the society. Next is the theory of law. You should understand that the theories of law are the ways through which people express their perception of law. And so because we have said law means different things to different people, we see that people also perceive law in different ways. And that is why we have the theories of law. And the first and the oldest theory we have is the natural law theory. And the natural law theory, one of the important proponents of the natural law theory is Thomas Aquinas and St. Augustine. Now, when you look at the natural law theory, you see that the proponents of this school of thought posit that there are basic tenets, there are basic principles that have been made by the divine, proceeding from the divine, which governs everything on earth. The natural law school do not believe that laws are made by man. No, they believe that law is a divine ordinance that directs and guides everything on earth. The next is the positivist school of thought. The positivist school of thought arose in response to the inconsistencies in the natural law theory. The positivist school of thought are of the view that law cannot just fall down from the heavens, that law must be formalistic, law must be certain. We cannot leave the law to the conscience in accordance with the natural law theory, who believe that natural law is discoverable by reason. The positivist school of law said no, that law is formalistic. Law must be written. The essence is that so that we'll be able to lay our hands and be certain about the provisions of the law. One of the important proponents of this school of law is John Austin, who defined law as a command of the sovereign backed by sanction. The positivist school of law postulates that every law must be backed by sanction. And that is the reason why under the characteristics of law, we identify coerciveness as one of the characteristics of law. The sociological theory is of the view that law exists in the society in order to solve societal problems. And so any law that does not seek to solve any problem is no law at all. Then we have the functional law, which views law from the point of view of the function that law performs in the society. We also have the historical school of law, the realist school of law that is posited, and then we have Oliver Wendell at the forefront of that realist school of thought, who posits that the law is the prophecies of what the court can do. And so whatever the court says that the law is, so be it. And that is the reason why people are looking at the legislature, as the judiciary as another law-making body, because the law does not take flesh except it has been interpreted by that arm of government. Then we have the utilitarian school of law. The utilitarian school of law also looks at law from the point of view of what the law can perform. Now we move to the sources of law, particularly in Nigeria. In Nigeria, we have the following sources of law. The received English law. The received English law is made up of the common law and the principles of equity. Now, what do we mean by the received common law? The received common law are those principles of law we acquired or we inherited from Britain as a result of colonial administration. We were colonized by Britain, as you know. Now, all our laws we are inherited from them. Their laws, they are, so to speak, their customary law, which we inherited from Britain, is what we refer to as common law. There are also sources of law in Nigeria. Now that at a point, the common law became so rigid that it does not offer the litigants all that they need. They cannot find all the remedies because the common law was so formalistic and so rigid. That gave rise to the principles of equity. The principles of equity emanated from the Chancery Court. It was at the discretion or based on the conscience of the Chancellor that these remedies now were made in order to reduce or to ameliorate the strictness of the common law. It is also a form of a source of law in Nigeria. Then we have the Nigerian legislations. The Nigerian legislations are all the laws that have been made either at the federal level, which are called acts, or at the state level, which are called laws. Now, at the civilian regime, they are called laws at the federal level and then laws at the state level. But during the military regime, they are called edicts at the state level and then decrees at the federal level. By whatever nomenclature they are named, Nigerian legislations are also sources of law in Nigeria. Then we have case laws and judicial precedents. Now, Nigeria is a Commonwealth country. By virtue of being a Commonwealth country, case laws and judicial precedents are important sources of law. These are decided cases. And that is the reason why we have hierarchy of courts in Nigeria, so that the law or the decision of a higher court will bind a lower court. For instance, a decision that is made by the Supreme Court binds the Court of Appeal down to the Magistrate Court and other courts. And so, case laws or otherwise known as judicial precedents are also sources of law. We also have customary law. Now you can understand that before the coming of the colonial masters, we already had our own customary law in place, regulating our conduct. It was not as if Nigeria does not have any law in place until the coming of the British. No, we had our own customary law. Until date, the customary law is a source of Nigerian law. The important feature of this customary law is that they are the norm. They are based on the culture of the people. And so that when these people have accepted these rules as binding on them, then it becomes binding on them. So that the courts will also need to judicially notice this customary law, particularly where they have not become notorious. But where they become notorious, the court will take judicial notice of them and will not need further evidence to prove them. Lastly, we have the Sharia law. Some people have looked at the Sharia law as another species of, but then this type of law applies strictly in the north, whereas customary law, they say, apply in the southern part of Nigeria. Next, we look at the classification of law. Law can be classified into international law, municipal or domestic law, public law, private law, criminal law, civil law, common and civil law, common law and equity, written and unwritten law, substantive, procedural, or remedial law. Now, when we talk about international law is the law that regulates the conduct of states. Municipal law is the law that regulates the life of people within a state. For instance, the law that regulates the people of Nigeria is a domestic law or municipal law. But where it regulates the life of Nigerians and Americans, then it becomes an international law. It operates at the international realm. When we talk about public law is that aspect of law that regulates the state or the life of a state. And that is some of the examples of public law are, for instance, criminal law. And that is the reason why when a crime is committed, it is not committed against the individual complainant, but against the state. Constitutional law is also a public law. Now the next is private law. Private law regulates just the life of individuals between themselves. Example of this private law is, for instance, contract law or the law of contract, the law of marriage, the law of wills or wills law. Yes, these are instances of private law. This is in contrast with public law. Then we have criminal law. Criminal law is the law that regulates crime. For instance, in Nigeria, we have two branches of law that regulate crime in Nigeria. We have the Penal Code Act in the north and then the Criminal Code Act in the south. Both laws regulate crime in Nigeria, so that if a crime is committed in the south, it will be regulated by the Criminal Code Act. If it is in the north, it will be regulated by the Penal Code Act. Then we have civil law. Civil law is also a kind of private law too. like contract law, law of tort, breach of tort. These are the classification of civil law. It regulates the life of individuals among themselves. And then we have common law and civil law. When common law and civil law are standing together, we are trying simply to talk about a legal system. Nigeria, for instance, belongs to the common law legal system. Now, the common law legal system are the type of law that operate by those states that were colonized by the British people. And under the common law legal system, what is very important is that case laws are important sources of law, quite unlike the civil law legal system, where only codes or statutes are the sources of law. Under the civil law legal system, the case laws are not recognized as sources of law. Then we have common law and equity. I have already explained this before now as a source of Nigerian law. The common law are the type of law that operates in all the states that were colonized by Britain. It is, so to speak, the customary law of the British people. The equity, that is the principle of equity, is that other arm of law that came in to ameliorate the strictness of the common law. Then we have written and unwritten law. Any law that is codified, that has been enacted and passed, is written. And any law that is not substantially written is unwritten. Yes, it is not just because it is not written at all. No. For instance, you can see that our customary law is somehow written, but then it is not a written law because it is not enacted or codified. So any law that has not been enacted or codified is an unwritten law. But that part of the law that is codified or enacted is written. Then we have substantive, procedural, and then remedial law. Whereas substantive law is the strict provisions of the law, provisions of rights and obligations as we have them in the books of the law. Procedural law or remedial law are those aspects or the procedure by which we enforce the substantive provisions of the law. Now, having said that, what are the functions of law? Law performs certain functions in the society. For instance, it is the means of social control, it is the means of social engineering, it is the means of social cohesion. It is used to define rights and create duties or obligations. It is the means by which disputes are settled and administration of justice made. It is also a means of social change, development, and planning. We also use law to provide for sanctions and punishment. And law also provides the methods of modification of the law, so that where the law requires modification as a result of a need that has arisen in the society, we also use the provisions of the law to amend such law or to enact another law. We also use the law to establish social institutions and then to regulate the powers of those in the society. Having said that, how does law regulate the conduct of people in the society? We have a number of techniques or a number of means through which law regulates the conduct of people in the society. The first is through penal technique. The second is through grievance remedial technique. Next is private arranging technique. We also have the administrative regulatory technique, the constitutive technique, the conferral of social benefit technique, and finally the physical technique. Now, when we talk about penal technique more or less applies to criminal law, where when crimes are committed in the society, punishments are used in order to deter future violators from committing such a crime. We also have the grievance remedial technique, where people who have their rights violated can seek redress before the court. This type of grievance remedial technique is applied by the civil law. or civil branch of law, whereas the penning technique is exemplary, seen in the criminal law as a branch of law. We also have private arranging technique, where people come together and arrange in accordance with the law what they want to be regulated in their lives. In this case, we have such things as marriage, where people come together, agree to enter into marriage, but provided that such marriage is made in accordance with the law, particularly with the Matrimonial Causes Act or the Marriage Act. We also have the administrative regulatory technique, where bodies are set up by law in order to regulate certain acts in the society. For instance, the Standard Organization of Nigeria is a regulatory body that regulates the conduct of people. NAFDAC is also a regulatory body that regulates the conduct of the things, the production of drugs, food, and the rest of them in the society. We also have the constitutive technique. This, for instance, happens in incorporation of companies, or where people come together in order to constitute themselves into a body that is recognized by law. For instance, the incorporation of a company, where people come together, constitute themselves into a company that becomes a person recognizable under the law. We also have the conferral of social benefit technique, where the society rewards those who do good and then punishes those who go contrary to the law. The essence of this is to help people in order to live in accordance with the law rather than violating the law. Then we have physical technique. This is also a method of regulating the conduct of the individuals in the society. This works by way of attaching a kind of tax or fines to what people do. For instance, the production of tobacco is allowed, but then there are certain kind of payments or tax that is imposed on the production of tobacco. The reason is that by so doing, so that the smoking of tobacco will be reduced to the barest minimum. We can see from all that we have said that law plays a very important part in the lives of the individuals in the society, so that every society requires the action of the law for its proper conduct. Law serves as a means of social control to deter the members from engaging in behaviors that would be harmful to the corporation or the corporate existence of the society. Remove law and the society turns into a jungle. Thank you.